Williams. Right, so thank you very much for sending through the bundle. I believe it was prepared by the defendant's solicitors. I've looked through the skeleton that was provided by the claimant. Thank you for that, Mr. Williams. And I've also read through Mr. Stewart's affidavit and the exhibit supporting that. I've got some preliminary views, and I don't think this will be a very long hearing at all. If you'd like to make some submissions, I think let's start off with that, and Mr. Williams can perhaps start off as the claimant's solicitor, and then we can hear from Mr. Jury. But like I said, I have kind of made up my mind as to which way I'll be swaying, and absent some pretty compelling submissions, probably I would say from Mr. Jury and Mr. Stewart, I am inclined to accept the submissions put forward by the claimant. Just so that we're confining submissions on particular points, I should say this. I don't think that today is the right time to set directions until trial. I think we should focus on the pleadings, and then we can have a case management conference after the pleadings have been exchanged to then set directions until trial. So, Mr. Williams, over to you, please. Thank you.
Thank you, Registrar, for those helpful indications. I'll keep my submissions short, and as you're aware from the claimant's skeleton, in effect, all we're asking for at this stage are some short directions to close pleadings and set the first CMC, all of which in accordance with the timeframes laid down in the.
Mr. Jury, I think you think that your mic's on mute, but it's not.
Apologies.
Thank you very much. Sorry, Mr. Williams.
Yes, that's much better. So as I was saying, you'll have gathered already from our skeleton that all we're seeking at the moment is directions to close pleadings and set a date for the first CMC, all of which within the time frame set forth in the RDC. So from claimant's perspective, it's a very straightforward matter, and it sounds as if the court is minded to view it likewise. So I mean, I've got a number of points about what in effect is the defendant's application for an extremely lengthy extension of time for service of a defence. Now, the claimant's position in that regard is that an extension of that length or any length is not necessary, and I'm happy to address those points in reply if that is a more economical use of everyone's time. I think just one point I would add before perhaps handing over to Mr. Jury is that claimant completely agrees that the CMC is the appropriate time to discuss deadlines for subsequent steps in respect of disclosure, witness statement, and experts. What claimants would suggest is that if the court agrees that this is sensible, that some time is set aside in the court's diary for the claimant's preferred trial date of September 2021, such that if we get to the CMC in January per the claimant's suggested directions for this hearing, that there's not an availability issue at that stage, i.e. the dates have got lost to other court users. So that would be the only submission that I make this morning to what's set out in our skeleton argument.
Thank you very much, Mr. Williams. In terms of the trial date, I don't think we'll have any problems finding a judge or sourcing a judge. We do have a number of judges on the bench, and we're in the process of introducing a handful of more judges. So I don't think that'll be a problem. I think, and typically we wouldn't set or even tentatively reserve a trial date until the CMC is listed, and rather the CMC order is issued. So I do agree with, like I said, your proposed timelines. I agree with the proposed timeline also for the CMC, and I've got no doubt that if trial was to proceed in September, we shouldn't have any issues finding a judge for you at that stage, but it wouldn't be right for us to reserve the judge at this stage. It's a little bit too early. So I think on this point, we'll hand over to Mr. Jury, so you can start us off with your submissions, please. I think what I'd like to hear from you is why the defence, for example, can't be filed within 28 days. I've read submissions from Mr. Williams on the amendments proposed, and the submissions, mind you, were very, very brief, but I can't see that the amendments to the particulars will be too substantial to the point where you'll need more than 28 days to file the defence. And I think that even if the amended particulars were very substantial, it shouldn't be at this point that you would seek more than 28 days to file the defence. It would be at the point that the amended particulars are filed. So I suppose I just want to hear more general submissions on why the defence has to wait. I get your point on disclosure. I get your point about the volumes of documents that are to be reviewed by your side. That makes sense, but typically that always comes at the disclosure stage, so later on, and that shouldn't impact what the defence says. So on this point, I'll stop talking and I'll hand over to you. Thank you, Mr. Jury.
Thank you, Registrar. In light of your comments, I think I'll focus my submissions on two key points. Firstly, why we say it's desirable for this document review to occur before we actually prepare our defence. Not only desirable, but very much in accordance with the overriding objective. The Registrar has our points as regards the quantum of documentation in this case, which is extraordinary. There's over 2 terabytes remaining to be collected. That collection, as per Mr. Stewart's witness statement, will not be complete until around the end of November. So realistically, the earliest that the defendants are going to have access to any review platform is probably December. And of course, we then have the Christmas and New Year interruption. But the first point in my submission will be about the desirability of that review, because the Registrar understands the quantum of the documentation at stake. The second submission I'll make relates to the differences between what was in issue in the application and the appeal and what is now in issue in the trial, because the two are very much apples and oranges, despite what my learned friend tries to depict in his skeleton argument. So taking the first point as to why we say it's desirable for this document review, or at least a substantial part of it, I hasten to add, should occur before we file a defence. Primarily in cutting through all this, it's to avoid the need to amend in due course. And of course, the Registrar will be aware that amendments to pleadings, particularly when they're substantial, almost always cause delayed procedural timetable, significant delay, such that you end up with a longer timetable than you would have had you set a realistic period to properly plead in the first place. As to why we say we need to conduct this review, my friend says, he points to the fact that there's no rule in the RDC that says you need to review documents to prepare a pleading, but I say that's altogether unsurprising, given that pleading practice requires you to plead material facts. The pleadings in the DIC court require, particularly for a defence, you need to assert admissions, non-admissions or denials, and for your denials under RDC 17.27, you need to explain your reasons for the denial, and you also need to assert an alternative pattern of facts. In this case, we're dealing with a 15-year period that's in issue, substantial documentation that will be relevant to those facts in issue. So we are necessarily hamstrung, not having conducted that review, in pleading the material facts for the purposes of the defence, without actually knowing what, at least in broad strokes, a large part of this documentation says. In terms of why we say this is important, it will narrow the issues in dispute, because if we have a better grasp of what the documents say, we may be able to make admissions, we may be able to narrow the dispute and really hone the court's decision-making process. And as I flagged at the start of my submissions, it is our strong view that if we have to prepare a defence in 28 days, it will necessarily be skeletal, because we will not have access to those documents until December. it follows that we will need to amend in due course, and it's likely that that amendment will be substantial. And of course, substantial amendments necessarily equate to delay. So in our view, the document review is entirely proportionate, it's necessary, and it will result in a faster procedural timetable ultimately. I would refer as well, just generally, to the overriding objective, and in particular RDC 1.6 sub 3, which talks of the need to deal with cases proportionately. And in particular, you need to be proportionate to the money at stake. There's $500 million on the line in this claim. It is a very significant claim. Secondly, to the importance of the case, the defendants, of course, are Dubai government agencies. So in the very unlikely event that there were to be a finding of liability, and we say that's preposterous, but if there were to be, it is ultimately the public purse that's at stake in this case. And thirdly, the complexity of the issues in dispute. It's quite clear here, bearing in mind that the immediate judgment application took 9 months to be resolved, it's quite clear here that there is a breadth and a depth of legal issues, not to even mention the factual issues that are involved in this case. Of course, in terms of the delay in rendering that judgment, that should not fall at the defendant's door in terms of fixing a reasonable and proportionate timetable. I would hasten to add, in terms of my second submission, which regards the differences between the application and what is at stake in this trial. As I mentioned, my friend tries to give the impression that all of the legal and the factual issues have already been ventilated in this application and that we have nothing further to traverse, which is just frankly wrong. In our letter of 30 April 2019, which is at page 59 of the bundle, and I'll briefly take the Registrar to that.
Thank you, Mr. Jury. Yes, thank you.
On the second page, headed Request for Disclosure, it's clear the application, quote, is a straightforward application based predominantly on a number of fundamental deficiencies in your client's claim as a matter of DIC law. And then under the subheading basis of the application, the second sentence, by way of summary, the points of law upon which the application is based include, without limitation. We then go on to set out what the points of law in issue were, and they include things such as the time for giving notice of termination under DIC contract law, fundamental versus non-fundamental performance, time bars, etc. So very much the framing and the focus of the application was deliberately limited to points of law. The defendants filed very little documentation in respect of that application. That being standard in respect of an application for immediate judgment or strikeout, because our proposition was that this dispute could be resolved on points of law. And of course, that was overwhelmingly accepted at first instance, but for one of the 8 grounds that were asserted. And then upon appeal, whilst we're waiting for the reasons of the Court of Appeal, it appears from the discussion of the hearing that the court might have been persuaded that there's a threshold issue, namely there are facts in issue that need to go to trial. Now, of course, those facts were never the subject of consideration by the defendants and have not been the subject of detailed consideration, precisely because we haven't reviewed and collected 2.5 terabytes of data, and it would obviously be inconsistent with the overriding objective for us to have done that and prepared our defence in circumstances where we said an application was pending that would have resolved the dispute, and indeed it almost did, bearing in mind the first instance judgment. So we say the issues in the application were very discrete points of law. The defendants have not traversed the factual material in any detail. They're in the process of collecting the documentation to enable them to do that. We will not have access to that material until the end of this month at the soonest. So bearing in mind the voluminous documentation that we need to at least make a fist of looking at to plead a proper defence, and a defence that will be of assistance to the court, we would respectively submit that the issues are very different now. The issues are issues of fact. And for example, some of the issues of fact that need to be traversed at trial, which were not an issue in the application, just to give the registrar a flavour, they include things like between 2004 and 2012, that is an 8-year period, did the defendants perform their alleged obligations under the agreement? For the purposes of the application, we had conceded, solely for the purposes of the application, the defendants had conceded breach of those obligations. So now that we're moving forward to trial, of course that concession is no longer applicable. We need to traverse 8 years of documentary material to determine what the defendant's position ought to be in respect of breach of the allegations that are asserted against us. That's a factual matter that requires a fact-sensitive review of the material, which is exactly what the claimant impressed upon the Court of Appeal at the hearing in September. Secondly, we need to determine when the breaches occurred. Thirdly, what was a reasonable time for giving notice of termination in having regard to those 8 years of circumstances. We also need to determine whether between 2012 and 2018, that's a separate 6-year period, did the claimant affirm the amended agreement? And again, that's a fact-sensitive determination that will turn upon a review of that documentation. So for all of those reasons, we are necessarily hamstrung in our ability to produce a meaningful defence that will advance the overriding objective and assist the court with the determination of the issues. I do think it is almost inevitable that there will be substantial amendments if the court is inclined to proceed with the claimant's proposal. And finally, I would just close by adding, as per the demonstrative that I provided yesterday, the proposal that we're making is not out of line with other commercial claims of this nature. Indeed, it's consistent with the kinds of timelines that one sees in significant, complex, high-value commercial disputes. Unless I can assist the registrar, that's the thrust of my submissions.
Thank you very much, Mr. Jury. Just out of curiosity, so I understand the procedural timeline with regards to this case, and the immediate judgment application was heard relatively early in, but then the judgment took quite some time to release, and then obviously it went to appeal, and the Court of Appeal then had to issue its decision. But was any groundwork done during that period in the event that the immediate judgment application was declined? I would think that prudent lawyers, particularly Gibson Dunn, being such a wonderful and excellent international firm, would have done some groundwork in the meantime in the event that things went pear-shaped. So what are your submissions in that regard?
In short, the defendants were entirely confident that the application would succeed, which was vindicated overwhelmingly at first instance. Of course, we're still waiting for the Court of Appeal's reasoning, and it may be that that reasoning was on the threshold issue, namely there is an issue of fact here to be determined, but that does not mean that the claimant does not have significant fundamental factual and legal problems with this claim, which we say it does. In terms of our preparation, we, as per Mr. Stewart's witness statement, we did start the document collection process. So we collected 500 megabytes of data, and then it occurred to us that we identified there was 2.5 terabytes of data, which extrapolates to hundreds of millions of pages potentially. So in those circumstances where the judgment of first instance came down overwhelmingly in our favour, it was very apparent to us, at least at the time, that it was not in accordance with the overriding objective to start that very detailed review, which frankly would cost hundreds of thousands of dollars. And I'm certain that had we done that and had we succeeded on appeal, we would be before you in a cost assessment, and my friend would be arguing that we should not have carried out that process and we should not have prepared a defence. So I believe firmly that our decision not to conduct that review, which would have cost hundreds of thousands of dollars, in circumstances where it appeared likely that the claim was going away based on fundamental legal and factual deficiencies, it was an entirely reasonable and proper decision not to start preparation of the defence.
That's very helpful, Mr. Jury. Thank you. Mr. Williams, do you have anything in response to say?
Thank you, Registrar. Just I think short points of reply. I'm not hearing anything in Mr. Jury's submissions that bring this case anywhere different from any other case that the court hears. The submission I'm hearing effectively is it would be more consistent with the overriding objective for parties to conduct disclosure prior to pleading, but that's not what the rules provide for, and it doesn't make procedural sense when you take into account that disclosure has to be framed by the pleaded issues. You're going through the documentation, deciding what meets the test for standard disclosure, what's in support of your case, what's adverse to your case or another party. So until you've set out the four corners of the case in your pleading, you're not in a position to interrogate the data you've collected in any meaningful way. So the discussion about 2.5 terabytes of data and however many millions of pages, that's just not an accurate representation of the task ahead of Gibson Dunn, because obviously custodians, date ranges, key wording is going to be applied to narrow that volume down. And of course, if Gibson Dunn are in a position to run those kind of interrogations on the data, then they're in a position to plead because they know what the four corners of the case and the defence are in order to target their review. So that's my first submission, and if that's not the case, then there's no credible basis on which that amount of data could be reviewed in any sort of conceivable time frame anyway. So it's of no assistance in the efforts to prepare the pleading. In terms of the pleading itself, the simple point is if the defendants were able to advance a strikeout and immediate judgment application, then they're able to plead the defence, because the thrust of that application was that the claim has no reasonable prospect of success, and that was on the basis of legal arguments and also a counterfactual that was put forward by their lead witness, Mr. Visa. So to suggest that the claimants, have no awareness of what their defence to this claim is and what the factual issues in dispute between the parties are, that's just simply not the case. As the Court of Appeal has recently held, in terms of the legal issues which the defendant is intending to plead as its defence, certain of those are fact-sensitive inquiries, and that will need to be explored in disclosure at a later stage of the case. But that doesn't mean that the legal issue and the factual parameters within which it sits are not known to the parties and able to be set out in a pleading, and there's nothing unusual about that. Mr. Jury refers to it being a skeletal defence, but the particulars of claim are 15 pages. I wouldn't necessarily suggest that a defence needed to be a much different size than that. It sets out the framework for the case, and then the factual issues in dispute based on the legal issues are always fleshed out subsequently in disclosure. Let me just consult my notes just to make sure that there's nothing else I'd want to pick up at this stage, if I may.
Yes, of course, go ahead.
Just one final point on the demonstrative, and I'm reluctant to raise this because it obviously came in late, but my submission with respect to that, leaving aside the timing in which it was submitted, was it doesn't assist the registrar. I mean, there must be countless cases that we could put in a demonstrative where the RDC timetable's been followed. I, sitting here as counsel, don't know the circumstances of those cases, don't know whether those timetables were consented to, the breadth of issues involved in the case. I just don't think it assists you. I think the parties have made submissions before you this morning. Nothing, certainly I've heard, has taken this case out of the ordinary. There's no reason why the defendant can't plead now and then continue with its disclosure efforts. And I noted Mr. Jury's points as to why significant efforts weren't undertaken in the period between the first instance hearing and the judgment 9 months later. And the argument was along the lines of, well, if we'd won the strikeout, then the case would go away and it would have been a wasted effort and cost. But that's belied by the fact that the defendants, engaged transperfect and started the collation in February 2020, a month before the first instance judgment. So if it was so important to them to get a grip on the documents, prior to taking the next steps in the case, they could and should have started that, a long time before February 2020. They should have started it, and in fact, they must have started it when the claim was filed in March 2019, in order to put forward the counterfactual that was argued in the strikeout application lodged shortly after the claim was filed in 2019. So I don't see any adverse effect can be placed on the claimant for the fact that the defendant hasn't got to grips with its case in the lengthy period of time it has already had at its disposal to do so, as the registrars noted, advised by an international firm of highly experienced in complex commercial disputes. And unless I can be of any further assistance, Registrar, those are my submissions in reply.
Thank you both very much. Look, I mean, on the sheet that was provided by Mr. Jury yesterday, which demonstrates the other complex commercial cases that came before the DIFC courts, unfortunately, Mr. Jury, there has been this mandate recently, which in fact is a directive from the governor of the DIFC and His Highness, which is to expedite cases as often as we possibly can. That's obviously not to say that we deal with cases in a quick and efficient manner so as to not deal with it in a way that is looking at the issues properly and under the microscope. We're saying, let's look at them properly, but let's always try to encourage parties to very efficiently dispose of their cases. We shouldn't be having cases that are running for several years. It's not, it doesn't serve the overriding objective, it doesn't serve justice, and it ends up incurring costs, etc. But look, I do hear your points, Mr. Jury, on the number of documents and the quantum of documents that have to be reviewed. I do also understand your points on costs, and I suppose I was perhaps fishing in that regard to make sure that you weren't unnecessarily accruing costs, which is something that is also very important when you've got appeal proceedings on foot. So I am prepared to be a little bit more lax with the timelines proposed, and I'm sorry to do this, Mr. Williams, but I don't think that the timelines proposed by Gibson Dunn are that efficient, really. So what I'm going to do is make you both happy, or perhaps both unhappy, whichever side you'd like to look at it, and meet you halfway. I think that both have provided sensible submissions. I don't think that we need to prolong the filing of the defence until February. It might mean that, Mr. Jury, you might need to put your head down and work through the festive period, unfortunately, to get your defence in. But I will grant you until the 14th of January to file the defence. That's on the basis that, Mr. Williams, the amended particulars will be filed by the 5th. Is that still a realistic timeline? And I'm just using the submissions made in your skeleton.
Yes, that's feasible.
Fantastic. So the amended particulars of claim will be filed by 4 p.m. tomorrow. The defence ought to be filed by the 14th of January. And like I said, that's to prevent the document disclosure, that's to prevent the defence from being amended and even the particulars from being amended too often. I've seen lots of cases where there's been several amendments to the pleadings and it does end up prolonging things. I will be keeping a very close eye on this case, and I would hope that applications to amend will not be made too frequently, or hopefully they won't be made at all. And I won't be very flexible in granting leave to amend often. But what I will do is grant leave to amend the particulars of claim. So you've got that leave, Mr. Williams. Like I said, 5th of November tomorrow is when you hand in the amended particulars. 14th of January is when the defence will be due. The reply to the defence, technically that's usually due 14 days after the defence is filed. Is 14 days sufficient, Mr. Williams, for you to review the defence, or would you like some more time?
We'd be satisfied with 14 days because I think we can anticipate what we're likely to see in the defence.
Okay, excellent. So 28th of January is when the reply to the defence will be due. I'll then give the parties 2 weeks to put their heads together and try and agree a case management timetable. If in the 2 weeks you don't arrive at a resolution in terms of all of the procedural dates up until the date of trial, then I would like to see an agenda of the items to be discussed at the CMC to be sent after that 2 week period. So 28th of January.
Registrar, if I may, and I apologise for interrupting, unfortunately all of the Gibson Dunn Dubai team are engaged in a 5-day arbitral hearing in the first week of February. So if it would be possible to have 1 extra week for the preparation of the CMC, we'd be very indulged by that.
Absolutely. So what we'll do is I'll give you 2 weeks from the 28th of January just to try and agree timelines. And if you don't agree timelines, then we'll go to CMC by, let's have a look. I mean, we're going to CMC regardless, but we'll go to CMC by the, beg your pardon? My calendar seems to be irresponsive today. So by the 18th of February, if I could please get, by the 11th of February, I would just like to gauge the parties' agreement on the CMC timetable. If you've agreed on it, then we can go to CMC the following week on the 14th. If you haven't agreed on it, and Mr. Jury, I hear you, you say that it's unlikely that you'll have any time and you've got quite a lot on in that first week of Feb, then we'll go to CMC the following week. So actually, let's make it easy. Let's not complicate it. Let's go to CMC on the week of the 21st of Feb.
Registrar, if I may just intercede.
Yes.
I think it's reasonable to assume that the parties are certainly not going to be 100% agreed on CMC issues, given I think we already know there's going to be disagreement amongst the parties as to the scope and length of time for disclosure, and thus, the length of time for the rest of the timetable and trial date. So, in claimant's view, if reply is going in on the 28th of January, we think it makes more sense just 2 weeks later, and in that intervening period, that we gear up for the CMC on the 11th, just so that there's not more unnecessary slippage in the timetable.
Yeah, may I just clarify, Registrar, I've just reviewed my diary. We have the arbitration hearing for 5 days, first week of February, and we're actually in the Court of Appeal on one of the correct matters on the 9th of February. So those, unfortunately, the first 10 days of February are going to be very, very difficult for us because all of the Gibson Dunn Dubai team are engaged on these hearings. So if we could have your indulgence to retain the CMC in the week commencing 21 February, we'd be very grateful.
Mr. Williams, because on the basis that there's only a week's difference, and what I would like to see before the 21st is an agenda anyways of the items to be discussed at the CMC. So why don't we agree that an agenda will be sent to the registry of the issues between the parties before the 16th of Feb. So 16th of Feb, I'd like to see all of the CMC documents, including an agenda of the items to be discussed, submitted in court. If you've got any substantive arguments on procedure, then please do prepare skeletons to be exchanged by 4 p.m. on the 16th as well. Furthermore, if you would like to provide a bundle, which is not compulsory, but if you would like to provide a bundle, and that's on the basis that you provided a skeleton as well, then please do provide it by 4 p.m. on the 16th. That will then give the parties 2 or 3 days, business days, to prepare for the CMC. Ideally, I'd like to book the CMC for the 22nd of Feb, subject to council's availability.
Yeah, that works for the claimants team.
Excellent. Mr. Jury.
Fine for the defendants. Thank you, Registrar.
Excellent. So we'll set the CMC for the 22nd of February at 10 a.m. That will be before myself. And any other issues will be dealt with on the papers. Mr. Williams, could I ask you please to prepare to agree a order with Mr. Jury on those deadlines that we've just discussed?
Certainly.
Thank you very much. Are there any other outstanding issues? I suggest that costs be in the case, unless there's submissions on costs.
No objection from the defendants.
No objection from the claimants.
Thank you. So costs in the case. Thank you very much.
Thank you, Registrar.
Thank you.
Thank you, Registrar.
Thank you. Bye-bye.
Bye-bye.